No. All right. Good afternoon. My name is Emily Belanger with the Louisiana State Bar Association, and welcome to our Law Talks virtual workshop series. This week is Lawyers and Libraries Week, and we'll be presenting a law talk every weekday at noon. Today's law talk is Wills and Estate Planning. We have attorney Hailey Manint with Legacy Estate and Elder Law of Louisiana presenting on this important topic. Before we get started, I need to go over a few important reminders. First, this presentation is being live streamed. Questions will be taken at the end if time permits and answered live. If you are watching at a library, you may walk up to the computer to ask or submit your questions to the library staff. If you are watching via Zoom, please use the Q&A section, and if you're watching via Facebook, please submit questions in the comments section. Please remember that all comments are public and visible during and after the presentation. Finally, please keep your questions general and not case specific. The attorney can provide information about the law and legal processes, but cannot give advice on individual cases. Please note that the information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials are for general informational purposes only. No viewer of this video should act or refrain from acting based on information provided in this presentation without first seeking legal advice from counsel in the relevant jurisdiction. If you need assistance finding legal help in Louisiana, please go to the Louisiana Civil Legal Navigator. The LSBA's inclusion of a program is not to be deemed a statement or an endorsement of the views expressed therein by the LSBA or any member of the LSBA. Speakers on LSBA programs were carefully selected for their knowledge, but neither the LSBA nor the speaker warrant that the presentations or materials were free from errors or will continue to be accurate. Statements in the presentations and their materials should be verified before relying on them. Opinions expressed are those of the speakers and do not necessarily reflect opinions of the LSBA, its sections, or committees. Views expressed are those of the authors and contributors only. And with that, I will hand it over to our lovely attorney, Hailey, to take over the law talk.
Thank you, Emily. Hi, everyone. Emily, can you hear me okay?
Yes.
Okay, great. Sometimes my audio likes to be funny, so if you suddenly can't hear me, just wave at me or something. All right. Hi, everyone. Like Emily said, my name is Hailey Manint, and I am an attorney here in Baton Rouge, Louisiana, and I practice in the area of estate planning and elder law. So today I'm going to be talking about how to protect your family and leave a lasting legacy. So to put that in simple terms, I know that, you'll probably hear people talk about wills, powers of attorney, trusts, but a lot of folks don't know what that means in their lives and how using them can protect them and their family members. So I'm hopefully going to demystify some of that today and kind of explain, why should you care? Why could this help you? Those kind of things. You can go to the next slide. All right, so this is just a little about me. I went to LSU twice. So nice, I did it twice. Got my law degree in 2021, and since then I have been practicing in this area of the law. You can do the next slide. All right, so what is estate planning is the major thing that we're going to be talking about today. And I'm going to help clear up some myths and misconceptions to help you plan and maybe help you realize what place this could have in your own family situation. And I'll discuss the specific documents that are commonly used in estate planning. And then we'll take questions at the end. Like Emily said, I cannot answer any specific questions. So no questions like my mom died and I need, whatever. But if you pose them very generally, I can probably answer better. I can answer general questions about the law, but nothing specific to your situation. Next slide. All right. So the first common misconception I think a lot of people have when they hear the term estate planning is, that's for wealthy people. I don't have an estate. I just have a house and a car and a bank account. An estate, when you think of an estate, you think of a sprawling mansion and all of this stuff. So legally, all it means to have an estate is you own something. So everyone has an estate of some sort. You could have $2 in your bank account, that's your estate. So estates vary from very large to modest to very small. If I find it most helpful to go through this by using some fictional people, our Tom and Cindy client. So these are not real clients, but we have made Tom and Cindy client out of a mashup of all kind of different clients that we've met with throughout the years. And these are very real situations. Every single one of them is things that we've encountered. Okay. So like all married couples, Tom and Cindy are looking forward to retirement. Tom's retired now, the age of 67, and Cindy is a school teacher. She's looking forward to retirement as well. Cindy has been on Tom for the last couple years. I think we need to go ahead and do some estate planning. My sister keeps telling me they went and saw an attorney. We really need to do that. Tom's like, I don't know. I've dealt with lawyers and I don't really trust them. I don't want to do all that. You can do the next slide. So Tom and Cindy have 3 kids, Peter, Paul, and Mary. So Peter is 32. He is not working. He is very motivated to make his band famous, and he is divorced and he's got 1 child. So not the most responsible of the 3 children. Paul is the middle child. Paul has Down syndrome, and he currently is receiving Social Security and Medicaid to support himself. And he receives help from his parents too. And then we have Mary, our classic oldest daughter, responsible, takes care of everything. She's married, 3 children. She's a CPA. So this is Tom and Cindy and their kids. You can go to the next slide. So this is Tom and Cindy's estate. Their family home is worth about $350,000. Furniture, household goods, about $50,000. There are 2 automobiles and they have a boat, RV. Maybe they don't have all that. That'd probably be more than $75,000, but somewhere in there. Investments around $300,000, life insurance around $200,000, and retirement plans around $300,000. So this is a fairly average estate that we may see people have, but we also meet with people with far less and far more. It's not a one-size-fits-all thing, and the assets that you have help to inform what we need to do to make sure that your plan works. Okay, you can go to the next slide. So like I said, your estate is everything that you own. So your home, your real estate, if you inherited real estate from your parents or someone in your family, it's very common in Louisiana that you might have inherited, a fractional interest in some land in a parish or maybe some mineral rights, and you get a little check every once in a while. That's all part of your estate. All types of money are part of your estate. Bank accounts, investment accounts, all of that good stuff. Your personal property, the things that you own, and businesses and anything that you own, essentially. You can go to the next slide. Also, your retirement plans and your life insurance policies. These are part of your estate, but they do function a little bit differently. So your IRAs, 401ks, all of that good stuff, that goes by beneficiary designation. So no matter what your will says, whether you have a will, don't have a will, your retirement, life insurance, all of those things will go directly to the person who you've named as a beneficiary. The only time the will comes into play is if you did not name anyone, then the estate will take over. So this is an important kind of asset and one that often does get overlooked. So those beneficiary designations are super, super important. Go to the next slide. So there's a lot of definitions of estate planning, but my favorite is control my property while I'm alive and well, plan for me and my loved ones if I become disabled, and give what I have to who I want, the way I want, when I want. So, what this means is estate planning is much more than what happens to my stuff when I die. That's a big part of it, but it's a holistic view at making sure that as you age, that everything is in place for you. So, good estate planning considers how do we make sure you have control and the best use of your property while you're alive? What would happen to me if I became disabled or incapacitated? I'm still living, but I can't take care of things for myself. And then when I pass away, what do I want to happen to my things? You can do the next slide. All right, here are what we might call the evils of estate planning. Some of them more evil than others. Some are just necessary evils, and then some are just things that we definitely want to avoid. So the first is an interdiction or guardianship, and I'm going to go into detail about that later in this presentation. Death probate, also called a succession. That's what happens when you have passed away and the court has to, recognize that you've passed away and give your things to the next generation, or whoever you said in your will is going to get it. And long-term care costs. We are not going to go into long-term care costs today just because of time, but just know that if you are concerned about long-term care costs and protecting assets to qualify for Medicaid, that is something that an estate planning attorney can help you figure out. Next slide. All right, here's probably the biggest evil of estate planning: procrastination. So like I said, Cindy's on Tom about getting to the attorney, and Tom is not interested. He thinks it's going to harsh his zen. He's doing yoga. But Cindy finally wears him down. You can go to the next slide. And they go to see the attorney that represented their son Peter when he got into some criminal trouble. That attorney said, I don't really do wills that often, but yeah, I'll help y'all out. Seems easy enough. That attorney did what we see a lot of attorneys who don't do this regularly. They will do what we call an I love you will. An I love you will is what we've nicknamed a will that married couples sometimes will do. And what that will does is says, when I die, I want everything to go to the surviving spouse. When the second of us have passed away, we want everything to go to Peter, Paul, and Mary, our children, in equal shares. Now, inherently, there is nothing wrong with this. We're going to discuss, how this might work for some people. The issue is this plan does not take into consideration a lot of factors and can cause a lot of issues if you haven't really talked it through with someone who knows what they're talking about and considered all of those things, okay? So these are the basic wills that Tom and Cindy gets. Now they've got peace of mind. They think they have everything together. Then they retire, travel, grandkids, etc., And then a few years pass, and unfortunately, Cindy is diagnosed with Alzheimer's. You can go to the next slide. Now, unfortunately, I don't know what it is. I'm certainly not a medical expert, but we are seeing more and more people being diagnosed with Alzheimer's and dementia at younger and younger ages these days. And Cindy, unfortunately, is one of those people. And her doctor warns her that, she will be experiencing cognitive decline. And now is a good time to get her affairs in order while she still can. But, she talks it over with Tom and they say, well, we got our wills done a few years ago. That's what they mean by affairs in order, right? We're fine. I'm just going to, enjoy the time I have left, and we're not going to spend any more time at the lawyer's office. So with their I love you wills, they just continue to live their life. You can go to the next slide. But unfortunately, accidents happen. So Tom is in a wreck and he survives, but he is in a coma and he is not able to take care of things for himself and he's not able to take care of things for Cindy. So as Cindy's been declining, he's been able to keep paying the bills out of their joint accounts. He's been able to help her with her medical decisions, all that stuff. But now that he can't anymore. So he recovers some, he gets out of his coma, but he never regains legal capacity. When I say legal capacity, I mean, does the person understand enough to be able to execute legal actions, sign documents, anything like that? So it's a spectrum, and he never regains the ability to understand enough to be able to sign any legal documents or handle his own finances or anything like that. So, as you may know, when you are unexpectedly injured, there is a list of people that the law allows to make medical decisions for you if you can't for yourself. So it would be like your spouse, your kids by majority decision, your siblings, on down the line. Not ideal, and there's ways around that, which we'll talk about, but there is at least an order. For your finances, there is no order. So you can't just go as Tom's daughter, Mary, to the bank and say, my dad had an accident. I need to be able to pay his bills. Can I have access to his account? They're going to say no. So there is no automatic person who can step up and handle your stuff for you if you are incapacitated. So now Cindy's incapacitated, Tom's incapacitated. Mary, their oldest daughter, is going to have to do something called an interdiction. An interdiction is called a guardianship or a conservatorship in other states. Well, Louisiana just needs to be different, so we call it an interdiction. An interdiction it means that someone has lost their legal capacity to make financial and healthcare decisions, but they haven't previously appointed someone to handle those things for them through a power of attorney. So they have to go to the court and say, hi court, look, my dad has lost capacity. You have to prove it to the court, and the court is going to choose who should be in charge of their decisions from there on out. Okay, you can go to the next slide. So there's a lot of disadvantages of this. It is very expensive to do an interdiction. The simplest interdictions routinely cost between $8,000 and $10,000. The reason for this is because you have to prove to the court that someone has lost capacity. They're not just going to take your word for it. So you have to have a medical expert say that they've lost capacity, and you have to pay for an attorney to represent the person who's lost capacity to make sure that their rights aren't being violated. This also takes a lot of time. Again, the easiest, most normal interdictions will take at least 4 months. And all your business is out in the street. You have to put into the court record everything that all your medical history, all of this stuff, and it's an open court proceeding where the person who's lost capacity has to sit in court and be talked about, and anyone who wants to go can go. There's a lot of things that have to be kept up with once the interdiction is granted. You have to do annual accountings, and you have to ask permission to do certain things with the interdict's property. And the worst part for a lot of folks is the decision about who's going to take care of you if you're incapacitated is not up to you at that point. It's up to the judge. So there have been situations that we've been involved in where two children both think they're the best fit. Or, somebody without children, a niece and a sister, thinks they're the best fit. They both go to court and say, I want to be in charge. Most of the time, when people are fighting about who's in charge, it means there's money to be had. Not to be a pessimist, but it's true. So This is something that you do want to avoid at all costs, and it is very avoidable in most cases. You can go to the next slide. So in order to avoid this, if something were to happen to you and you become incapacitated, before you become incapacitated, while you still have legal capacity, put these documents in place. This is an integral part of every estate plan. And sometimes, I feel like it is the most important part, because I talk to a lot of people, and a lot of people will tell me, why would I spend money and do things about when I'm dead? I'm going to be dead. I don't care what happens. And a lot of people only associate estate planning with their will. But this really affects you while you're living. These documents, and there are a part of every estate plan, if you go to an attorney that practices this area of the law. Sometimes when folks go to someone who's maybe not as experienced, like Tom and Cindy did, they don't include this as part of the planning, and it's very important. So a property power of attorney or a financial power of attorney is a document where you say, while you have your right mind, you say, if I'm ever incapacitated, I want this person to handle my finances. So in this situation, Tom could have said, I want Cindy to handle my finances. If Cindy can't, I want it to be Mary. That would have avoided this whole interdiction process. Same with healthcare. You can appoint who you want. So the law says if you've got kids, your kids are going to make a decision by majority vote. However, if you have a healthcare power of attorney, you get to say, I don't want that. I want it to be who I want to make decisions. So if you've got a sister that's a nurse or something, you don't want any of your kids making decisions. You could say it's her. If your kids don't get along, you can say, okay, I don't want y'all fighting. I want it to be specifically you. We also do HIPAA authorizations. We find that a lot of clients want to be able to provide people they're close to with information about their healthcare. So if they were suddenly hospitalized, they would want all of their children to be able to come and get information from the doctor, but they may not want all of their children making decisions. So the HIPAA authorization is a separate document that says who can have access to my information. And then your living will is something different from a last will. So a last will is probably what you're most familiar with. A last will is saying, when I die, give my stuff to X person. A living will says, if I am ever in a situation where I am being kept alive artificially by machines, then I don't want to be kept alive that way. Essentially, pull the plug. So this is something that a lot of clients find comfort in. They don't want their family to be the ones to have to make that decision. So they, in advance, do a document saying, if I'm in that position, nobody has to make the decision. I've already made it. So integral part of estate planning is these powers of attorney, and it can avoid that interdiction process if something unexpected happened to you. Okay. All right, next slide. All right, so after a few years, after Mary has had him under an interdiction and she's been handling his finances and helping her mom, Tom passes away. Next slide. Now, Tom's I love you will is back in the conversation, right? He's passed away, and now his last will is on the table. And the problem is he has given his entire estate to Cindy. But remember, Cindy was diagnosed with Alzheimer's a few years ago at this point, so she has cognitively declined significantly. Now, she no longer has the capacity to sign legal documents. So poor Mary has to go back through the interdiction process for her mother because Cindy does not have the legal capacity to handle Tom's estate or receive Tom's estate and continue to handle her own business. You go to the next slide. Now, let's take a different scenario. Let's say Cindy is well, she's doing good. And she's doing so good, in fact, that she decides now that Tom has passed away, she wants to start dating the pool boy. Okay. Her and the pool boy hit it off. They have a shotgun wedding. Now she says, you know what? I'm going to change my will and I want everything to go to the pool boy. This is not what Tom would have wanted. He would have thought that everything was going to go to his kids after Cindy died. But unfortunately, these I love you wills do not protect that. They do not give any remarriage protection provisions. So at the death of the first spouse, the second spouse can change their will. There's nothing preventing them from doing that. They can give it all to the pool boy. They give it all to one child. In blended families, this becomes a problem. Maybe they write out the stepkids. So there are ways to, if there is a concern about that in a specific situation, there are ways to plan for that as well. All right. Next page. So the problem in some cases with outright distribution, and what I mean by that is giving the people that you've named in your will a lump sum of money directly, or a lump, the property directly, not holding it back from them in any way. When you just write a normal will and you say, I want everything to go to whoever, it's going to just go to that person. There's no strings attached. You can't control it in any way. So outright distributions like this may fall short of your estate planning goals. And I will give you some examples of how it fell short in Tom and Cindy's case. You can go to the next slide. All right, so Paul, the middle child with special needs, he inherits 1/3 of the estate upon Cindy's death. So remember, Tom's died, everything went to Cindy. Cindy passes away. Now her I love you will goes into effect, and it's going out to the 3 kids, okay? So Paul's getting 1/3 of his parents' estate. However, Paul is on SSI and Medicaid. And as some of y'all may know, SSI and Medicaid, you're only eligible for those things if you have assets and income under a certain amount. So Paul receives a lump sum of assets and a bunch of property, and he is kicked off of his SSI and Medicaid. So not only does he not have a steady income anymore, he is going to have to find alternate healthcare until he spends through all of his parents' money and is back to the point where he can qualify for it again, which is not the outcome anyone really wants. Next slide. Peter, the other child who's, working on his band and not doing the best in life, he gets his lump sum and spends all of his money on drugs in a short period of time. And this is a concern for a lot of clients that we see, whether it be drugs, gambling, anything like that. They say, if my child came into a lump sum of money, I'm very concerned how that money would be spent. So Peter's 1/3 is gone very quickly. This leaves Mary, the oldest child, wondering, what could my parents have done better? They had a will, they thought that was enough. Why am I still stuck with this headache of dealing with their estates? And both of my poor brothers have had a bad outcome from this. So let's talk now about some techniques for how to pass along your stuff when you die. You can go to the next slide. I think this one's like, it goes, yeah. So the first technique, spend it all. I hear this a lot. You see bumper stickers on the street, on like fancy cars and stuff saying, I'm spending my kids' inheritance and stuff. One way to do it, but you never know when you're going to pass away. So that might not be the best. You could do nothing. If you do nothing, meaning you don't have a will and you pass away, the state of Louisiana is going to fill in the blanks and say what's going to happen. So if you have a spouse and children, your spouse gets what's called a usufruct over your community property when you die. A usufruct is the right to use the property until you die or you remarry. So this is not a great outcome for your surviving spouse. When your surviving spouse thinks, I'm going to have free reign of everything when my spouse dies, and then, you know, a lot of people just assume, oh, everything would automatically go to my spouse. We've been married for 40 years, you know? That's not the case. This is especially bad in blended families because when the second spouse, the living spouse, dies, the kids of the first spouse to die are going to have a claim against the kids of the second spouse to die, saying, hey, when my dad died, the estate was this much, and you need to repay it to us. Okay. So there's a lot of minutia in that, but long story short, in those situations, it really sucks. If you pass without a spouse, but you've got children, your estate would go equally to your children. If you pass without a spouse and without children, your estate would go to your siblings, and your parents, if they're still alive, would have a usufruct over it. If any of your siblings have passed away, their portion would go down to your nieces and nephews, their children. This gets complicated fast. This is how 25 people end up owning one house and fighting about it, okay? So doing nothing is not what I would recommend, but it's an option. Next one. Another thing people ask me is, well, why can't I just give it to them all now? For some things, I think that advice is great. If you've got a ring or a necklace or something that can easily be misplaced after you die, I think those are great things to give while you're living. It's a meaningful gift and it makes sure it gets to the right person. But when we're talking about real estate and money, there's a lot of issues with this. Some people say, you know, I'm going to donate my house to my daughter, but I'm going to keep living there. She's not going to kick me out. And I'm going to give her all my money too. She'll just give me money when I need it. But what happens when your daughter gets divorced? Now, half of that is her ex-husband's. Or what happens if she gets in an accident and she's sued? Now, all of that is stuff that can be taken to give to whoever sued her. So this is not a good situation for a lot of folks. The next one. Designating a beneficiary. This is great, but only works for some assets. Works for retirement accounts, life insurance, annuities, things like that. So it's not going to work for your house, for your run-of-the-mill bank account, for your normal investment accounts, things like that. So yes, this is a helpful tool, and it's something I encourage everyone to do at least once a year, is go check that your beneficiaries are who you want them to be, but it's not a cure-all. Next one. Signing a will. I think this is a great idea. I'm very pro this idea, but I would like to say that it takes an experienced person that does this area of the law to make sure that the unintended consequences of these I love you wills are not what happens in your situation. And then finally, the last one, implement a living trust. I'm not going to go too much into detail about the trusts, but just know that it is another way that you can hold your stuff and distribute it to your children when you pass. I'm going to go into a little detail about it, and this is a great option for some people, but depending on what your specific situation is, we would recommend a will or a trust based on what we hear from you. Okay? There are many different kinds of trusts. The trust that Paul needed, so the special needs child, Paul, in our example, would have been a special needs trust. Tom and Cindy could have done this in their wills, or they could have set up a trust separately. And which one is right for you would be dependent on the situation. But what Tom and Cindy could have done is said, in their will, when I die, I want 1/3 to go to Mary, 1/3 to go to Peter in a trust controlled by Mary, and then 1/3 to go to Paul in a special needs trust controlled by Mary. What a special needs trust is you can think of a trust as a bucket. It's something that holds assets. It holds the 1/3 of the estate that Paul came into, but it hides it from being eligible assets or eligible income for SSI and Medicaid. So he's not going to lose his benefits if it's in a special needs trust. But the great benefit of it too is that Mary is the one who holds the purse strings. Mary decides, okay, it seems like Paul needs, a new wheelchair. It seems like Paul needs something, and she can use money from the trust to pay for what Paul needs. So it doesn't have to just be spent immediately and all gone just so he can get back on Medicaid. He can keep his benefits and have that extra, money for when he needs it. And then the same thing with Peter. Peter didn't need a special needs trust. He doesn't have a disability that would make him qualify for a special needs trust. He's just what we like to call an irresponsible heir. They could have put the money that was going to Peter, say, keep it in a trust for Mary to control as the trustee. Mary then holds the purse strings. So Mary, Peter could come to Mary and say, I want $100,000. Mary said, what is it for? He didn't give a good answer. She said, sorry, no. She can go and decide, okay, you need a place to live. We're going to pay your rent with this money. You need a car. We're going to buy a car with this money. But he doesn't just get a lump sum of money to spend on drugs or gambling or whatever. You can go to the next slide. So like I said, there's a lot of reasons that an outright distribution in a will may not be good for the people that you want to give stuff to, whether they're young, if they're children is a big one. If you have young children, we would want to talk about how we can structure your plan. So if something happened to you, the kids would have their stuff in a trust to be controlled by a trusted family member. Irresponsible heirs like Peter, we just talked about. Lawsuits, if maybe one of your children has a pending lawsuit against them and they might have a big judgment against them and you don't want them to come into a lump sum of money. Public benefits, like we just talked about with Paul. Predator protections, if somebody is really gullible and might give their information out to anybody who calls and asks for it, that's another reason. Okay. So go to the next slide. There's two common methods of creating a trust. Sorry, my phone's ringing. Two common methods of creating a trust. So you can create a trust within a will. So you can make a will and say, I don't want to deal with making a trust right now, but when I die, I want this trust to be created to hold the stuff that would have gone to Paul or would have gone to Peter. You can also create the trust while you're living, and there are some benefits to that. You can go to the next slide. So you can create a trust while you're living and transfer all your assets into it. And if you do this, then there are some benefits to it. This is kind of like front loading the work. It's kind of taking on more work now so that your kids have to do less later. But the trust contains instructions just like a will for distributing property at your death. And the trust, you can go to the next slide, has 3 positions. The grantor, which is the person who creates the trust. The trustee, which is the person who deals with the business of the trust day to day. And the beneficiary, this is the one that you want to be, if you can. This is the person who benefits from the trust, right? So, like I said, I'm not going to go into too much detail. And there are a lot of situations where I would recommend somebody look into doing a living trust like this. But in a lot of situations, a will is great. It just needs to make sure that you fully think about the outcome for everybody in your family instead of just doing these I love you wills. Okay. So next slide. So let's imagine that Tom and Cindy, instead of going and getting their lazy I love you wills, went to an experienced estate planning attorney And after learning about this, they decided that they were going to create a trust. Okay. So if they created this trust while they're living, they would have complete control over everything in the trust. And then when one of them lost capacity, the other person could continue to do it without any need for an interdiction. And then when the second of them dies, Mary, who is the successor trustee, you can go to the next slide. The successor trustee, Mary, is the one that can take over when her parents become incapacitated or they pass away, and it's a very seamless transition. Okay. And the trust, if you put all of your assets into it, you can avoid going through the succession process because there's nothing left in your name to do with the court to transfer to the next generation. Okay. Like I said, that's a very high level overview of trusts. There's a lot of different kinds of trusts, and finding out if a trust is right for you would be a conversation between you and an estate planning attorney. For most folks, like I said, wills work great, but just making sure that they are personalized to you. So go to the next slide. So after you pass away, whether you had a will or not, you have to go to the court, and the court will sign off on a document that changes the ownership of your property to whoever you've given it to, or whoever the law says gets it if you didn't leave a will. Okay. This is called probate or successions in Louisiana. That's what we call it. And you can go to the next slide. In Louisiana, we have something called a small succession. And this is available for folks who die with less than $125,000 in assets. In today's world, if somebody owns a house, they probably are already not able to take advantage of this. It's an easier way to do it, but it's not available in all situations. So it might be something that you've heard of, have people have done, and it's great if it's available, but it's not always available. So when you don't have any planning in place, this death probate or succession can be really difficult. Like I said earlier, especially with blended families, especially, this becomes just a tug of war of things that people never thought they would start fighting about. But if it's not written down, then the law says what's going to happen. And the usufruct business that I described earlier is really not the outcome that most people would have wanted if they had written a will. So if there's any contention in this process, it becomes a lot more expensive and a lot more time consuming. So having a will in place generally in most situations helps to bring a lot of clarity to this process, and it helps people from fighting because there's no, daddy would have wanted this, daddy would have wanted that. Well, daddy didn't write it down. So we have to go by the law. If he had written it down, we could do this a lot cheaper and faster. Okay. Then go to the next slide. Like I said, this can be expensive if people are disagreeing, but we are actually a little bit lucky here in Louisiana. Other states have mandatory laws that say the lawyer gets 5% of the estate as payment, which in some states that's a lot of money. Louisiana doesn't have that. Louisiana lets the lawyer choose how much to charge, and that needs to be reasonable. But who gets to decide what's reasonable? At the end of the day, the judge gets to decide what's reasonable if there's a question about it. Our firm strives to give flat fee. If there's no one that's disagreeing, we try to give a flat fee because we like to know, we like you to know that this is what you're going to pay. And I like to know that anytime you want to call me, you're not worried about, oh, how big is my bill going to be? I want you to be able to have small talk with me without worrying about it. So that's why I like it. That's what we try to do in most situations for successions and estate planning. The only time we can't do it is when there's an unexpected element and we don't know how long it's going to take. Okay. All right. Go to the next slide. So the living trust or will, which one should I have? You know, you told me all the benefits of them. How do I know which one I need? So your will ensures that your property goes to who you want it to go to, you can protect young or irresponsible heirs within your will, but it's a little bit more roundabout, and you can do some things to protect from creditors and divorces, but you can't do the remarriage provisions. You can't prevent your spouse from changing their will. So there are some disadvantages to wills. You go to the next slide. The trust can provide better disability protections. It can protect irresponsible heirs and from creditors and stuff like that more fully. At the end of the day, it's a conversation that we would have to have based on your individual situation. I think a will works great for most people, but there are a lot of situations where we would want to really look into a trust. All right, go on. So we kind of already talked about this. You can keep flipping. If you do nothing, the state of Louisiana decides what happens with your property if you don't leave a will. And then if you don't have a power of attorney, there will be an interdiction potentially if you lost capacity. And these are the potential downsides of that. Next slide. So some people say, well, you know, somebody told me that you can just handwrite your will in Louisiana. So why wouldn't I do that? You can. You can handwrite your will in Louisiana. That is allowed and legal. However, there are form requirements that are a little bit persnickety, and some of the messiest successions I have ever dealt with have been from handwritten wills, because the person who passed away didn't realize what they did when they wrote the will, whether it wasn't in the right form, so it was invalid, or they wrote something they thought meant one thing but actually means another in the law. So yes, you can write it yourself, but I extremely caution people who want to do that, you know, law firms make some of their best money from people fighting about handwritten wills. So I do not advise it. And then there's all these online services now where you can do your wills. I looked at there's a website called Kiplinger or something. I looked at that. I looked at their Q&A section and copied and pasted it here. Why can't residents of Louisiana use self-help will preparation materials online? Because our legal system is very different. Most of these online will things that you're going to see are going to have an asterisk and say, not good in Louisiana. Because, like I said, we have to be different. Louisiana is just quirky. So if you're using these will forms you find online, the better chance than not, it's not going to be good here. Okay. So next slide. Seeking competent legal advice would certainly be my preferred method of the ones that we've talked about. Okay. All right. Well, that's really it as far as the presentation. I have seen some questions come through. Emily, how do we want to handle the questions?
So we will pull up the questions and read them out loud, and then you can answer them live as we go through it. So thank you so much, Hailey. That was awesome. So it is the time for questions. So feel free to post any questions you have in the Q&A section on Zoom or the comment section on Facebook. Okay, and we can get started. Okay, first question I see is, can you change a will made by two spouses when the husband is already deceased?
Yes. So everyone has their own will. You can't do a joint will. So you can't do, two people can't have the same will, but you can go at the same time and do your will. A lot of spouses do that. So if one of the spouses has passed away, the other spouse can absolutely change their will. The only way you can restrict that is if you had set up a trust, or if you had set up something that specifically restricts your access to do that. But if it's just a normal will, then yeah, you can change it.
Amazing. Okay. Second one I see is, can you handwrite a HIPAA?
No, I don't think that any doctor's office is going to take a handwritten HIPAA.
Okay. What are the caveats to a handwritten will being acceptable?
They actually just changed the rules on this like last month. It has to be completely written in your own handwriting. It has to be dated and signed by the person who wrote it. And I might be forgetting something, but that's the basic stuff. And my concern with the handwritten wills, it's not even that I think like most people, you know, can follow the form instructions of it being dated and handwritten and all of that stuff. It's more the actual language of the will can very easily get muddled when you're not used to using these legal terms. So I had a handwritten will brought to me recently where the person said that they wanted all of their stuff to go to one person to be used for the benefit of their niece who has special needs. What they accidentally did is created a trust in their will, and they didn't want to do that. So that's just an example of why I really caution against those handwritten wills.
Yeah. Okay. Next is what is the average cost for a will with the living trust, special needs trust?
I can't really give an average cost because it depends so wildly on your personal situation. Um, if you came to our firm, we try to be really upfront at the initial consult about how much we think that things are going to cost. It varies, wildly between the different places that you may go. So I'm sorry, I can't give a specific answer. But I can say wills are cheaper than trusts because trusts are much more involved.
Can you have a trustee who is not an American citizen and doesn't live in this country?
I believe so. I don't see why you wouldn't be able to. It might make things a little bit more logistically difficult, but I don't see why not.
Which trust is ideal for young adults?
So for a young family, if they've got it really depends on your goals. So if you've got young children and you want us to make sure that your children are protected if you passed away, then you could do simple wills and have a trust that's goes into effect if you passed away unexpectedly that would hold the property for your young children. Or you could go ahead and set up the trust in current time. And that is also a possibility. It would really just depend again on your situation. But the main thing is if you have young children, you would want to talk to an estate planning attorney about making sure if something sudden happened, that the kids are protected. And if you're a young married couple or someone who doesn't have children, I think simple wills would be plenty enough if your estate is fairly straightforward.
What would be the number one reason you would advise doing a trust over a will?
The number one reason, well, there's so many different kinds of trust, but I guess the trust that I talked about today would be if you want to do something where you can't give an outright distribution to someone. And those are kind of the reasons that I said, an irresponsible heir, someone with a drug problem, a gambling problem, a special needs child, a young child, things like that.
Can my husband change his will after I die if he's usufruct of the house but does not own the house?
If you pass and you've only given him a usufruct of the house, he can't then give away the house because he only has usufruct of it during his lifetime. So he can change his will, but he can't give away a house in a will that he doesn't own.
Mhm. Under $125,000, did you say you needed a succession?
You don't, you may not need a full succession with the court. You may be eligible to only do a small succession affidavit which is cheaper and quicker. But it depends on the situation.
Um, do you need a separate trust for home, business, and bank acts?
No, definitely not. It would all be in the same trust.
Um, do you know of a website to find legal help in Louisiana? Search for an estate attorney.
I don't know if there's a central website. I mean, I know that the LSBA has the attorney. You might know better than me, Emily. I think there's a way to find attorneys on the
We
website.
do. We have a way
Yeah.
to find attorneys on our website. We have a directory of all the attorneys in the state of Louisiana. And we will actually, I will tell y'all at the end of the presentation about a few of the resources we have that can assist you with finding an attorney, finding legal aid, etc.
Mhm.
Is a revocable trust better than an irrevocable trust?
Ooh, that's a big question. An irrevocable trust is usually used when you're trying to plan for long-term care and Medicaid. That's probably the most common use of it. There's other uses, but it's the irrevocable trusts are most commonly used for Medicaid planning or for very wealthy people who are trying to, you know, do some fun tax stuff. But the most regular folks, if they're going to have a irrevocable trust, it's because they um, are planning for Medicaid purposes, which I didn't get into today. Um, so I can't say that there's one that's better than the other, but most folks, unless you're doing that long-term care or there's some other reason to do an irrevocable trust, we would more be looking in the revocable trust area.
Yep. Okay, and the last, I purchased more life insurance and want my children to use it to pay off the remaining mortgage. Can that be entered in a will or a trust?
So if you cannot control how somebody uses life insurance in a will, you can't say, I gave you life insurance, use it for this. You can give life insurance, you can name a trust as the beneficiary of life insurance and then have your trustee say what happens to the benefit, to the money. That's the only way you can kind of control it from beyond the grave.
Right. What's the difference between living trust and personal property trust?
I guess personal property trust would be like a gun trust or something like that, where there's a reason that you would own a specific piece of personal property in a trust for legal reasons. I'll be honest, I've never really done anything like that. But that's seems to me what it would be like. The living trust is more for your for all purposes, for your whole estate, whereas personal property trust, like a gun trust, would be I want to own this specific kind of gun and I want to send it to my kids without the legal loopholes or things like that.
The parents live in a different state from the child. Which state should the attorney be retained in for creating a trust?
Where the parents live. Mhm.
Okay. The final question I'm seeing right now is, does legal aid assist in forming wills or trusts? The answer to that question is that they do some succession work, some wills and succession work. You would have to reach out to either Acadiana Legal Services or Southeast Louisiana Legal Services. They cover both of those programs cover the entirety of the state, so it's just a question of which parish you live in and who services that parish.
Southeast will not do trusts. They will do a will if you qualify, and they will do simple successions.
Perfect. Okay, so while we're waiting to see if any more questions come in, I want to highlight some additional resources. These may be helpful if you have a legal question that was not addressed during this presentation, or you need help getting assistance. This is a flyer for the LSBA's Find Legal Help page where you can access a continuum of resources. It includes our attorney directory, the civil legal navigator, legal aid and pro bono organizations, the modest means directory, and self-help services. I'd like to call special attention to the Louisiana Civil Legal Navigator. This is a great tool where it diagnoses your problem, helps you identify your legal issues, and provides customized information, referrals to legal aid, and more. It is simple to use and will give you next steps specific to your issue and or your parish or location. You can also access free legal answers, which is an online pro bono program that allows users to log in whenever and wherever they like and ask civil legal questions and have attorneys answer those questions through the site. It is private and acts almost like an email exchange between the user and the attorney. Please note that users must meet certain income guidelines to use this program. And this is our Find Legal Help flyer for all those research I was just talking about. And I'm gonna wait a few more seconds to see if there's any remaining questions. I know we're a little over time, but I want to make sure we have everything complete. And it looks like we are all good on questions. I don't see anything else coming through. So that concludes our Law Talk workshop for today. Please save the date for our next Law Talks during Lawyers and Libraries Week. It will be tomorrow at noon. And they will be discussing how to navigate online legal resources. Thank you so much, Hailey, for presenting on this important topic. Everything was so wonderful and so very useful. And yes, just thank you so much.
No problem. Thanks, everyone.
All right, and we will go ahead and close out on that. Have a wonderful afternoon, everyone. Bye.